Hi, everybody. It's Mike Kennedy, Vermont Bar Council. Trying something new this week with the answers to the 5 for Friday quiz. A video answer where maybe I can give a little bit more explanation to each response than I do in the blog itself. In my kitchen, wearing my hat for 2 reasons. Yes, the Steelers won yesterday, and it might be our last win of the year, so that's worth celebrating. More importantly, we're whatever we are in almost 2 years into the pandemic and virtual stuff, and I've yet to figure out decent lighting in my house to do these videos. And trust me, when I say I've yet to figure out decent lighting, my quest to do so is for your benefit, because if I wasn't wearing my Steeler hat, any of you who have seen me without a hat on would know that the light would be reflecting so brightly off my big bald noggin right now that you wouldn't even be able to see anything, which wouldn't help when we go to video to help explain the questions. Okay, so vtbarcouncil.com or WordPress vtbarcouncil.com. I can't remember what it is. VT Bar Council, just Google that. Questions will be there. The introduction to the quiz, a couple quick comments on that. I mentioned my mishap with the coffee on Friday morning. Really want to give a shout out to Jack McCullough. Jack's an attorney for the Mental Health Law Project with Legal Aid. And he pointed out that instead of having to choose between leaving the 6 cups of water in and or dumping the 6 cups of water out, when I realized I didn't have enough coffee to make 6 cups, I could have simply just pressed start, run the water through, then started over from scratch with the 2 cups of water that I had to match the 2 scoops or 4 scoops or whatever it was of coffee that I had left. Good point, Jack. Thank you for raising that. A couple other people mentioned that took issue, I would say, with my practice of keeping coffee in the freezer. That's where I keep the coffee because that's where I like it. It's my coffee. And I'm the one who has to drink it. So that's why I like it that way. That said, I will take you up on your suggestions in the spirit of being open to new things. And I will, since then, Friday, maybe it was Saturday, I took my coffee out of the freezer and I now store it in a cupboard where it's at room temperature, which some of you have informed me brings out the oils. Great. I'll try it. Like I said, here's the deal. I'm not exactly into coffee for the oils and the coffee. I put so much half and half in my coffee. And then that's another thing I'm very superstitious about. The coffee tastes better if you pour the half and half in first and then pour the coffee over it. It's more of like a natural mix. So like if I go to a restaurant and I have to whip off those little cream things and pour those in, no, the coffee's already in first, they're going in second. It kind of throws me all out of balance. So again, I just lost track of what I was thinking about. Oh, so again, yeah, it's not the oils or the warmth of the coffee. It's for me that drinking coffee is an exercise, an excuse in being able to drink something that's loaded with half and half. Then the subject of the blog, the intro was about embracing that sort of downtime between Thanksgiving and the holidays and how it could be time to recharge and refocus. A lot of people appreciated that. Somebody made a great point that I actually thought about this morning when I woke up and realized I didn't get anything done this weekend that I wanted to do associated with the holidays. Namely, wanted to buy my tree and I wanted to decorate my place. I love doing that at Christmas. Usually get everything up early, keep it up late into January, helps my mood through the winter. I didn't get any of it done. And someone had written in with their quiz responses and said, Mike, it's not exactly nothing. It's a time to prepare for what's to come. And that was a great point. And I didn't do that. And I think a lot of us could do that at work too. I know I could be better at doing that at work. When I feel like I'm in a downtime at work, I often don't continue to like stack wood. Like in the old days, in the summer, it wasn't just time to play. You had to stack the wood to make sure you had the wood to get through the winter. And if you waited too long until winter was upon you, it might have been too late. So I didn't cut and stack wood this weekend. I actually literally took my advice and embraced nothing. I did nothing. And now I'm a little bit behind. So that was a fair point, and I'm glad the reader raised it. Okay, so let's go to the questions. Share my screen, give you a chance if you haven't taken it yet to actually take the quiz with us as we go through the answers. See if I can figure out this part of technology. Okay. One sip of coffee. Not only is my hat old school, kind of the pom-pom, this coffee mug given to me by the first ever basketball team I ever coached. It was a freshman team at South Burlington High School, and they made it and they put all their names on it. They've worn off. It's been that long, but a licensed lawyer's name is on this mug, Chris Dahl. Chris was on the first team I ever coached. Very good player. If you know Chris, tell him I said hi and tell him you saw him in this video. Okay. So I often blog and talk about the 7 C's of legal ethics. This C does not appear by word in the rules of professional conduct. That said, and as the Vermont Supreme Court has indicated, this C is a serious violation of the trust accounting rules. Which C is it? I'll give you a second to think about it. The answer, commingling. So commingling is when your own money is in the trust account. That is not good. And when I say that the Supreme Court has indicated that it's a serious violation, I mean it. And this is what the Supreme Court has said. The court has said, well, generally, when it comes to attorney discipline and attorney discipline cases, there are a range of potential sanctions that can be imposed in any case. They range from an admonition, which is a description of conduct that does not identify the lawyer, but it says why the conduct violates the rules. Then we have a public reprimand, which is also the description, but identifies the lawyer, description of the conduct. Then a suspension, then a disbarment. So suspension, disbarment, describe the misconduct, identify the lawyer, and impact the lawyer's ability to practice for whatever the period of suspension is or disbarment. And just as an aside, in Vermont, we do not have permanent disbarment. It's 5 years, after which the lawyer can petition to come back. But anyway, commingling. The court has said that in almost all cases, commingling is such a serious violation that the admonition is not going to be available. That sanction that describes what happened but doesn't identify the lawyer, that the baseline sanction for commingling will be the reprimand, where the lawyer will get identified. Now, there are some exceptions. There could be circumstances that mitigate to the extent that we will depart downward, to borrow a phrase from the federal sentencing guidelines, we will depart downward to the admonition, but the baseline sanction will be that public reprimand. So remember, if your money is in the trust account, get it out, pay yourselves on time. The failure to do so is commingling. The only exception we have to the commingling rule is you may maintain in the trust account either your money or the firm's money, but only in such an amount as to cover reasonably expected charges and fees that your bank will impose on the account. Changed that rule about 10 years ago, maybe. Remember, you can't just dump money into the account and say, oh, that money will be for any charges or fees that my bank imposes. It has to be reasonably related to charges that you expect. So if you are running a lot of transactions through your account, and for whatever reason, there's a lot of fees or expenses charged, go ahead, put that money in. And if that's $500, then because that's what you expect in fees and charges, do it. But if there's only $2 charged per month or per every couple months to your trust account because it's not very active, don't put $500 in, put 2 in. The two have to be, the amount has to be tied to the charges that you reasonably anticipate. I also will accept, a couple of readers responded, conversion, because that's also a serious violation. It wasn't what I was thinking about, but it's serious. It's so serious that in Vermont, there's a case that I prosecuted from the mid-2000s where conversion, which is also misappropriation, taking money from trust that belongs to a client that you've not earned yet and using it for your own purposes, the baseline sanction will be disbarment. Even if the money goes back before the client knows that it was gone, and even if everybody's made whole. So, I don't want to get into it. That's not for the point of this video, but don't use other people's money as if it's your own. That's conversion, and that's a serious violation as well. Okay, question 2, sort of a longer one. They don't feel this long on the blog, but when I look at them on these slides, whew. Okay, every now and then I'll receive an inquiry in which a lawyer asks whether there are any pitfalls in allowing someone other than the client to do this. Referring to the three prongs of the applicable rule, I respond, 1, make sure you get your client's informed consent. 2, don't let the person interfere with your independent professional judgment or your attorney-client relationship. 3, don't disclose confidential information to the person without your client's consent. So given my response, those three prongs, it's most likely that lawyer who called me asked whether there are any pitfalls in allowing someone other than the client to do what? Is it A, serve as a go-between between the lawyer and the client? B, make decisions that are ordinarily reserved for the client? C, sit in for the client at a mediation that is likely to cause the client undue stress? Or D, pay the lawyer to represent the client? This one, I think pretty obvious. The answer is D, pay the lawyer to represent the client. The prongs of the rule are in, the three prongs I mentioned are in 1.8F. Comes up in several scenarios. The most common that I see where lawyers get a little confused, not necessarily confused, but they almost violate the rule by accident, is in divorces or DUIs, low-level criminal cases, where parents are paying for a child. It could be an adult child even, but parent is paying for the child's representation or a relative's representation. If that happens, mom and dad are paying for the divorce. Mom and dad often want to know information. They want to know your strategy. They want to know what's going on. Same in a criminal case. Hey, what's up? You can't tell them that. The third prong of the rule is make sure not to disclose confidential information to the person without your client's consent. So even if somebody other than the client is paying, you still owe a duty of confidentiality to the client. And the fact that the payor is paying does not create an exception to that duty. This rule also comes up, obviously, in the insurance defense context. But I just lost track of what I was going to say next. So anyway, those are the scenarios in which I've seen the rule arise. If somebody other than the client is paying and there's money left over at the end of the representation, generally the money is to be refunded to the person who paid it. The client can't say, hey, by the way, I know we only used $3,000 out of the $5,000 my mom gave you. You got to give me that other $2,000. Call me if that happens and we'll talk through it. Question 3, another fill in the blank. I guess I wasn't feeling very creative 72 hours ago. A comment to one of the rules includes the following statements. The same word correctly fills in each blank. An action is not blank, even though the lawyer believes that the client's position ultimately will fail. The action is blank, however, if the lawyer is unable to make a good faith argument on the merits of the action. Two possibilities here, frivolous and meritless. The frivolous is the word I was looking for. It's the word that appears in the rule. That's one of the comments to Rule 3.1. I don't see this very often. My guess is it might come up in the trial court more often than at courts than it comes to our attention. I actually don't recall the last time we got a complaint alleging a frivolous action. Just remember, you can start a case. This happens a lot in injury claims where the statute of or tort claims where the statute of limitations is to run. If you have a good faith argument on the merits, and the comment to the rule goes on to suggest that that will include doing further investigation, you can make sure to protect the client's rights by getting the action filed. Can't make stuff up to do that, but if you have a good faith argument, you can file it. Question 4. Oops, going the wrong way here. So apparently I'm all screwed up. I just showed you the answer. So you should know the answer because I have the slides out of order. Anyway, finally, another version of fill in the blank. During a CLE, I say something like this. Comment 3 to the rule addresses whether matters are substantially related. It includes a sentence that makes clear that we will not require the blank to disclose confidential information to keep the lawyer from using it in the subsequent matter. Given my statement, I was discussing which rule. Is it A, the rule that governs conflicts between current clients? B, a lawyer's duties to former clients? C, candor to a tribunal? Or D, trick question, it's a rule that's not listed in choices A, B, or C. So the choices do not fill in the blank. I took a phrase out so as not to give away what the answer would be. what did I take out? Oh yeah, I went in reverse. So the missing words in that blank are former clients. So I'm just going to show you that the answer is duties to former clients. Here's the question. Again, the blank is, we will not require the former client to disclose confidential information to keep the lawyer from using it in the subsequent matter. Now, I did a video on this last week where I talked about the former client rule is you can't switch sides. And I used the example of being at basketball practice and I'm working with one group and I tell the people in that group, here's the play we're going to run. And I tell it in secret so the defense can't hear it. Something happens, so if someone on defense has to check out, got hurt. We send somebody from the offense over. We go to run the play. Whoa, coach, the one you just sent over knows what we're going to do. That's not fair. She switched sides. That's an example of a conflict. So we would obviously tell the group a different play, then they would go do that one so that the one who switched teams doesn't have an unfair advantage. Now, a couple of people responded, and it's a fair response. Well, Mike, you only have to do that because the person who switched teams in your basketball practice knew what was coming. I represented the former client 5, 6, 7 years ago. I don't remember anything about the case, so it's not the same. It doesn't matter. We've said both in the comment to the rule and in a Supreme Court case that if the new matter is in fact substantially related to the old matter, we are going to presume that you received confidential information in that former matter, the type of information that would always be imparted from a client to a lawyer in a matter like that. Further, we are not going to put the client to the Hobson's choice, the Vermont Supreme Court has said, of having to disclose a confidence in order to protect it. So remember, when it comes to the duties to former clients, if two matters are substantially related, it doesn't matter a whit that you don't remember the first matter, okay? Substantially related, you're out, absent the former client's informed consent. Then finally, this week, question 5. In the introduction to the quiz last week, I alluded to stress that can come with the holiday season. So last month, a judge in Georgia made national news after tweeting a mock order banning a popular holiday item from the judge's county, the entire county. I don't know whether the attention caused the judge any stress. Anyhow, the mock order referred to the stress and anxiety that can come to parents who forget to move the item, as well as to children who touch the item and thereby deprive it of its holiday magic. Name the item. I don't have one, obviously, because I don't have children. And I don't want my mother getting me one and sneaking in here and moving it around every night. Mom, don't do that. The answer is the Elf on the Shelf. So that is, by the way, I heard from a couple of readers that the order has been rescinded and that the Elf on the Shelf is allowed again in Cobb County, Georgia. I also know that the makers of Elf on the Shelf have issued a response where they don't hold it against the judge. They believe that the judge remains on Santa's nice list. That's what they actually said in their response. Anyway, if you have any questions, give me a call or email and we can talk about these issues or any others. Other than that, hope you have a great week and thanks for watching and listening. Bye.